Good morning. We're going to call the meeting to order. Before we give you a little floor show before the meeting started, we did. We'll start with the minutes, and then we're going to go into an early public comment period. As you can see from the agenda, there are several variances, I guess, in two major sets to be considered, and they're significant enough so that we, as in the past, are allowing for two public comment periods, and we'll begin with the public comment period after the minutes on all the variance requests, the two sets of variances. So can we begin with the June minutes, which have been distributed? Any comments? Any?
Move to approve. Second.
All in favor?
Aye.
Approved unanimously. And let us go into the comment period. Sarah Kerr, Legal Aid Society.
Good morning. My name is Sarah Kerr. I'm an attorney with the Prisoners' Rights Project of the Legal Aid Society. These have been difficult weeks where we have watched the excessive use of force and use of weaponry take the lives of many in this country. Orlando, Baton Rouge, Falcon Heights, Dallas. We have watched the use of extreme, excessive, and deadly force against people by police when the situation did not require such force, and watched the tragic death of 5 policemen. We are experiencing the divide that such violent events can create between us, between races, between the poor and the wealthy, between law enforcement and regular citizens, between those who would carry guns and those who would control the availability of guns and ammunition. This may not seem relevant to today's proceedings, but I find that these events color most of my thoughts and are unfortunately extremely relevant to where we are this morning. It is the role of the Board of Correction to set minimum standards for the conditions in the city jails. It is not the board's role to remove all standards, to relinquish its independent authority over jail conditions, or to provide carte blanche for the Department of Correction, the mayor, the Correction Officers Benevolent Association, and or other associations of uniformed staff to do as they will. Yet the amended variance posted last night at approximately 9:55 p.m., the night before this meeting, seeks to delay, remove, or reduce many significant protections in the board standards from an undetermined number of people without a developed factual basis and before the needed concerted effort through leadership and training to implement the reforms that were passed through the CAPA process. Our written comments, sent based on the first variance request letter, not the amended posting late last night, reflect the one-sided representation of facts by the DOC and the last-minute nature of their claims that they could not end punitive segregation for the young adult population, all of them, all 18 to 21-year-olds. The switch from the July 1 deadline that passed 10 days ago and the assurances just days prior that the deadline would be met to the current assertion that rulemaking will be necessary to continue punitive segregation or use ESH in some form for the people in our jails who are between the ages of 19 to 21 makes no sense and cannot be supported. DOC has not provided facts demonstrated that it cannot safely and securely for staff and inmates, for staff and the young adults, house this small group of individuals in less restrictive settings than punitive segregation. There are only 9 young adults housed in punitive segregation. This age group is entitled under state and federal law to a high school education if they have not already completed it. DOC has historically denied these rights to the members of this age group that it holds in punitive segregation, relegating them to self-study that is no substitute for education. The city has repeatedly assured the court in our Hanbury litigation that punitive segregation for this group is about to end. And so all high school eligible youth will be attending school and that no youth are held in ESH. So the DOE need not provide education there. At a bare minimum, if this board intends to grant the variances, it must condition them on the requirement that any placement does not affect the education of any of those who are still completing their high school education. The board has already passed a limited rule. The board has already compromised and protected only individuals through the age of 21 instead of through the age of 25. The board has already delayed the timeline repeatedly. The board passed the termination of punitive segregation for the 18 to 21-year-olds based on evidence of the permanent harm that punitive segregation causes to developing brains. Do not forget the actual facts, that there has never been a correlation between the increased use of punitive segregation and reduced violence in our jails. Punitive segregation does not increase safety for staff or inmates. Do not now back away. Do not reject the evolving standards of decency and jail management that were incorporated into the minimum standards before they are implemented. This board must not participate in or stand by during the ratcheting up of the weaponry, addition of tasers and pellet guns, dogs searching public buses, increased use of segregation and restraint, the continuation of torture through punitive segregation. This board must not permit the DOC to dictate the direction of the rulemaking and minimum standards in the city jails. Your role is not to stand by and accept compromises that make no sense, lack factual basis, and make our jails less humane. Your role is not to accede to a failure of staff to buy into best practices and needed reforms. Your role is not to stand by and watch leadership and managerial staffs of DOC refuse to lead and manage and enforce your standards. It is the role of the Board of Correction to set and enforce minimum standards for conditions in the city jails. Do not eviscerate the board's standards or your role as an independent agency. I urge you to vote no. I can't breathe. Thank you.
Angel Castro.
Good morning, everyone. Once again, it is COBA's position that placing some of the most violent offenders who happen to be from the ages of 19 to 21 in cages with staff is not direct supervision housing. And once again, the department is showing that it is unready to keep everyone.
Thank you. Ellis, who's continuing process? Elias Huzmendi. Not here? Okay. Jennifer Parrish.
this information is documented in solitary confinement of youth in New York, a civil rights violation, which was published by the New York Advisory Committee to the U.S. Commission on Human Rights. The chairperson of that committee testified at the board December 2014 hearing, along with Children's Defense Fund, Children's Rights, and other experts. Children's Rights reinforced this information about neuroscience and young adult brain development and pointed out that, quote, best practices in child welfare require that the system provides supports to assist youth in developing relationships with significant adults and peers, because research shows that young people are more likely to succeed if they have a good relationship with at least one caring adult. Older youth will develop social support networks and build healthy, meaningful relationships with caring individuals. Just as in child welfare, building social networks must be a priority for older youth involved in the criminal justice system in order to develop necessary skills and brain functioning to transition into adulthood. Children's Rights goes on to say, research and intervention models developed in child welfare show that placement of and services to adolescents and young adults must address trauma and normalize young people's lives. Institutionalized youth need more contact with trusted adults and peers, not less. Excessive isolation is incompatible with current research and policy for older youth today. The science on this issue has not changed, and neither should the board's commitment to rules passed in January 2015. In continuing to grant the department's extensions variance after variance in excluding young adults from solitary confinement, the board must remember that individual lives are affected by the choices it makes. I am compelled to raise the example of Gabriel Vasquez, highlighted in the Daily News article published 2 weeks ago. His situation is a tragedy of our system. Someone whose mental illness is apparently burying him in the criminal legal system, a place that does not know how to care for him. I do not know all about Gabriel's individual situation, so I'm extrapolating from what has been in the Daily News and is publicly available information. We should all be concerned about the systemic problems that his case represents. Gabriel has been in jail for more than 5 years, since 2011. He was 19 years old when placed in Department of Correction custody. He spent a significant amount of time in Maui, Mental Health Assessment Unit for Infracted Inmates, which is now defunct, but it was solitary confinement for people with mental illness, and it was horrific. Gabriel should probably never have been incarcerated, as his initial charge stemmed from riding a bicycle on the street and ended up with a confrontation with police officers for which he was charged with assault. But as a result of his incarceration, he is now facing other charges, a charge of arson for starting a fire in his cell, which is one thing people frequently did in Maui to escape those horrific conditions. He reportedly has bipolar disorder and has had a series of defense attorneys, which has extended his jail time. He's missed court appearances more than 20 times, reportedly for refusing to do so, but likely also because of restrictions placed on him, such as the requirement of a captain's escort, which keep people from making it to court appearances. As Candy Haley has told the board in the past, and was confirmed during her trial, during her time in solitary confinement, correction staff were largely responsible for her missed court appearances. What if Rikers Island had not had solitary confinement for 19-year-olds when Gabriel came into the system? Would he still be incarcerated? What if we knew how to offer the care needed to this troubled young man? This board must not allow young people to be scarred by isolation, neglect, and brutality. We cannot allow the torture of solitary confinement to continue. I hope that the secure unit will be a place in which the adults, correction staff who are paid to be professionals and to follow rules will provide the support that young people need there. But I have grave concerns about it. The physical space is in no way inviting or calming. Unlike even ESHU, which is painted in bright colors, the secure unit is a series of cages in which 8 young adults will be closely confined. Unless it is run by caring staff who will commit themselves to building rapport with the young people and making it a safe environment for them there with engaging programming, this unit will be yet another dangerous, punitive housing area. I was dismayed to see that the department cited the union's opposition to ending punitive segregation in its variance request. The union has been against the changes to punitive segregation from the outset and has contributed to the culture of brutality that the Nunez litigation was designed to address. If we are going to have meaningful change in the way incarcerated people are treated, then the department leadership must stand firm in its vision for reform, and staff posts that interact with young people, with young adults, must be committed to contributing positively to these young people's development and acting as positive role models. If officers are unwilling or unable to commit to this vision, then more civilian correction counselors are needed to be brought on to achieve real transformation. Thank you for the opportunity to speak. I hope that the board will provide significant oversight of the secure units and will not allow these variances to pass. Thank you.
Charlotte Pope. I think it's Pope.
Test.
My name is Charlotte Pope from the Children's Defense Fund, New York. Thank you for the opportunity to testify. We were concerned by the contents of the June 30th variance request that asked for a 6-month extension of the deadline to extend punitive segregation for people ages 19 to 21, and we cannot support board approval at this time. We appreciated the board's response letter that was looking for specific facts or reasons for noncompliance and specific plans to reach compliance. Considering that there were only 9 young adults in punitive segregation at the time of the variance request, we hope that the board also asks the department how punitive segregation will be used while the secure units are piloting, whether an increasing number of 19 to 21-year-olds will be placed in punitive segregation going forward, and what steps the department will take to transition away from punitive segregation, as was the intention of the secure unit. In our letter to the board, we asked if this variance is considered that a 6-month extension be limited to 2 months and that the department be required to submit a new variance request in September in time for the next public board meeting that includes new information and reasoning relevant to the circumstances present at that time and does not rely on a vague overview of events in the month of June. Late yesterday evening, an amended variance letter was posted that requests to place young adults in ESH. Given the history of ESH and its changing uses, we ask that the board seek clarification on how ESH is being used today, including details on length of stay and criteria for entry, as well as the number of young adults expected or intended to be placed there. Given the lack of details and the last-minute nature of that request, we ask that you delay the vote on the variance at this time. Thank you.
Thank you. Kelsey De Avila.
Hi, my name is Kelsey D'Avila. I'm the Jail Services Social Worker at Brooklyn Defender Services. And today I'm just going to share a story and a few quotes. Can you hear me? Again, my name is Kelsey D'Avila. I'm the Jail Services Social Worker at Brooklyn Defender Services. And today I'm just going to share a story and a few quotes from the clients that we represent. Mr. S. is a young person who suffers from schizoaffective disorder and a learning disorder. During his incarceration, Mr. S. was the victim of stabbing and burning attacks when he resisted pressure to join gangs. When staff failed to de-escalate conflicts with Mr. S. over things like lost property, he was issued infractions for disobeying orders, and he was eventually placed in the Restrictive Housing Unit, or RHU, a solitary unit for people with mental illness. The isolation endured by Mr. S. contributed to his decompensation, and he began to experience more regular auditory and visual hallucinations. Mr. S. became increasingly depressed and hopeless while in the RHU. At one point, he shared his sense of hopelessness with staff, and in response, he was placed on suicide watch in an empty cell with nothing more than a smock. After coming off suicide watch, Mr. S. was denied all out-of-cell time, access to privileges he had earned through program compliance for the next 3 weeks. In short, staff's response to a perceived suicidal statement was to isolate Mr. S. entirely, 24 hours a day in his cell for a month. Mr. S. was discharged to the community directly from isolation. The next are several quotes from some of our clients who are in isolation. Being in isolation makes you emotional, aggravated, because you're helpless. You have to ask for everything, to be fed, showered, to talk to your family. It takes away your sanity. If you make people desperate, they're going to act desperate to get what they need. You take away people's contact visits, people are going to do whatever they have to get off that unit. I'll go to the box. I can go in there. I feel like the walls in my cell are closing in. I want to smash my cell apart. I was hitting my sink earlier. I don't know what to do. I don't know how much longer I'm going to make it in here. I understand people break the rules and there have to be consequences, but if you treat us like animals, we may as well behave like animals. We need things to rehabilitate ourselves so you can go home better. But this isolation is turning me into more of an animal. These comments were sent to you earlier this year when the DOC asked for a variance, and BDS shares these same stories again because not much has changed, and these are the same stories that we hear from our clients. And BDS strongly requests that you deny this variance. Thank you.
Riley Doyle Evans.
Good morning. Riley Doyle Evans. I'm the Jail Services Coordinator at Brooklyn Defender Services. Thanks for the opportunity to testify this morning. I'll try to keep it brief because we've been here before and you know the things that I'll say because we've heard them last month, we heard them 6 months ago, we heard them 2 years ago, including those stories. For those of you who were on the board when we first discussed this matter and the board adopted rules, those were the stories that we shared, and nothing about the harm that those people experienced has changed. When the board adopted the rules, the statement of intent and purpose that introduced the rules described the practice of solitary confinement of young people as a serious and unacceptable threat. That hasn't changed. I remember where we came from before these rules were adopted and before solitary confinement was ended for 16 and 17-year-olds. I hope you do too. I hope you remember that we had clients who were in solitary for hundreds of days, for the entirety of their incarceration. Many of them were sent upstate to endure state prison sentences after the damage that was done to them in isolation. Many of them returned to our communities where they were our neighbors, they were our children, they were our family members. And the young man who Kelsey talked about, Mr. S., he was discharged to the community and offered a program, but he found the program incredibly difficult because largely it involved interacting with other young people, something he hadn't done in months and months. Unsurprisingly, he failed the program and was later sentenced to a term in state prison that lasted several years. He's still there. The thing that I want to comment on is just the profound disappointment that I think we all feel about the process that led to this variance request. 6 months ago, Judge Hamill and Mr. Cephas raised the concern about finding ourselves at this moment, having seen the 6 months go by and still not having ended solitary confinement for this population. The Young Adult and Adolescent Advisory Board and the members that compose it has been eager to be a part of this process and to see New York City lead the country toward an end to solitary confinement. But instead, when we toured the secure unit on the 27th, or the 28th rather, of June, staff didn't mention that we should expect another half year of solitary confinement for these young people. And a letter from the department the day before, assurances were made that despite a delay in separating this population from the rest of the adult population, that we shouldn't expect any delay in ending solitary confinement for this population. And yet, On the 30th of June, a letter was sent describing what the department claims to be in extensive detail, but I would argue is relatively general in nature, an emergency situation at GMDC that requires 6 months to resolve. We're glad that there's been some changes to the variance, but the reality is, from our opinion, this is a moment that you should be taking advantage of. There's an incredibly small number of people in solitary confinement in this cohort now, and the department should be commended for that. They've done a tremendous job in getting that census down. Leaving that unit open only opens the possibility of putting more people in it, and opens the possibility of each of those individuals being a challenging move to get them out. And so I won't be surprised if in 6 months another variance is put in requesting an extension of solitary confinement, and I won't be surprised if sometime in the future, when a crowded solitary-like unit that is the secure unit fails and the CAPA process is initiated again to undo the momentous change that you all initiated almost 2 years ago. I hope that that doesn't happen, but I won't be surprised. We urge you to reject this variance, take this opportunity and end solitary confinement for this population. It's already too late. Thank you.
Thank you. Ruthie Epstein.
Hi there, my name is Ruthie Epstein. I'm the Deputy Advocacy Director at the New York Civil Liberties Union. We applaud the ongoing efforts of the Department of Correction to reform solitary practices in New York City, which have led to a significant reduction in the number of people held in solitary on Rikers, according to DOC's own data. However, we're concerned that the department is now making its 4th request to delay the end of solitary for young adults. We recognize the very real management challenges that this change presents for the department, as detailed in the Commissioner's June 30th variance request, but the city first agreed to this plan in January 2015. They have had a year and a half to prepare. Therefore, we join other advocates today in urging the Board of Correction to deny the Department of Correction's variance request. By its own admission, the DOC today holds only 9 young adults in solitary. Surely the department can find a different solution for these individuals that supports their rehabilitation and their basic human rights, rather than subjecting them to a practice widely condemned as torture. We all know the well-established devastating effects that solitary confinement can have on young people. Indeed, that's the very reason the DOC has proposed to remove them from solitary confinement, for which they deserve credit. Every day that a young person spends in solitary confinement is a day where they are subject to brutal conditions that pose a risk to their mental health and their psychic well-being and may damage them irreversibly, with severe consequences for them, their families, the staff at Rikers, and ultimately our communities when they return home. There is, in short, no question that we must get young people out of solitary confinement as quickly as possible. At the same time, we know that solitary confinement is deeply ingrained at Rikers, as it is throughout all our jail and prison systems, and that a long-term plan to end solitary for young people must be carefully and thoughtfully implemented. The question before the board today is how to strike an appropriate balance between ending the daily damage being done to young people detained at Rikers and held in solitary, and ensuring the transition away from solitary confinement is accomplished safely and permanently. We believe that balance is appropriately struck by denying the DOC's variance request. It's unclear that the DOC can definitively point to the removal of young adults from solitary as the cause of the increase in violence last month, nor is it clear what safeguards the DOC put into place in anticipation of June's population increase at GMDC. We strongly caution against any conclusion that solitary confinement is the only way to prevent violence among young adults on Rikers. In fact, the department's June 30th letter makes the case that reducing solitary does not on its own lead to an increase in violence. Quote, reforms have resulted in an 80% reduction in the number of inmates in punitive segregation and the imposition of stay limits. During this period of dramatic reform, we, the DOC, also successfully decreased violence. Bold reform objectives and steady progress toward those objectives are absolutely critical to permanently transforming the culture at Rikers and eventually, we believe, paving the way toward closing the jails on the island. The NYCLU respectfully urges the board to deny the DOC's current variance request. Thank you.
Thank you. We're going to proceed now with the substantive agenda. We will move to, and I'll turn it over to Judge Hamill in a moment, the committee update on adolescent and young adults, and in that context, ultimately turn to the department and consider the variances that the department has submitted. Judge Hamill?
Good morning, everyone. Well, as we all have seen, there's been a dramatic turn of events after the last board meeting, resulting in deprivation of some basic minimum standards to young adults housed out at GMDC, including recreation, sick call, health and mental health appointments, as well as a clear violation. Is that working? Is that working? No, I'm not sure. As well as a clear violation of our regulations requiring elimination of punitive segregation for the ages of 19 to 21 by June 30th. I just want to share with you the chronology as I understand it, because being transparent is very important. The Department of Correction has repeatedly assured the Board of Correction, including me personally, that it could comply with the June 30th date to end solitary confinement for young people. The Board of Correction put the Department of Correction on notice during the month of June that we were observing some non-compliance with our minimum standards, that there was excessive lockdown, and that was as a result of field staff reports, central office reports, and board member tours out at GMDC. The Department of Correction took action as outlined in their June 27th letter to address the problems, but specifically stating it would have no effect on the ending of punitive segregation on June 30th. On Thursday, June 23rd, when I was informed that Secure was supposed to open, I went out to the Secure unit and observed the Secure unit. There was a lot of staff, deputy wardens, someone's from the commissioner's office, but there were no inmates, and no one could give me a date as to when the inmates would be definitively coming. On June 28th, the Department of Correction hosted its Adolescent Young Adult Advisory Board to tour the Secure unit, and although I was not personally there, staff and advocates report that, again, they were assured that punitive seg would be ending. So as of Tuesday, the information presented to the Board of Correction is that it would be ending. On June 29th, that's the Wednesday, is when Secure finally opened at 1 o'clock in the afternoon, but with only 3 inmates. Up until that point, the board had been assured that the 9 young adults, and it actually had gone down to 7, I believe, had safe, secure alternatives to punitive segregation, and they would be able to end punitive segregation. It's my understanding that the union was opposed to the opening of Secure, and I believe one of the union officials just said that there was some opposition to the Secure unit, and as we all know, they have been opposed to the ending of punitive segregation. On June 30th at 6 p.m. is when I first was notified that punitive segregation was not ending. And thereafter, starting July 1st, the commissioners started filing emergency declarations declaring an emergency variance for 24 hours pursuant to our regulations. Now, there were some dates that there were no emergency declarations, and I had an opportunity to discuss this with board members and Commissioner Pont last week, and thereafter the Board of Correction issued its violation notice. I wish to share with you some history and background, which some of the advocates have specifically mentioned for all of us who have been involved in this for about 2.5 years now. The Board of Correction was in the midst of rulemaking during all of 2014. We heard from experts, national experts, local experts, community advocates, all the various agencies involved. We know the Department of Justice did a comprehensive investigation and report and found pervasive violations of youth civil rights out at Rikers by virtue of excessive and unnecessary use of force, as well as the overuse of punitive segregation in the 16 to 18-year-old cohort, which was the focus of their investigation. The New York State Advisory Committee to the U.S. Commission on Civil Rights did a comprehensive investigation and report in December, found that a minority youth are disproportionately subjected to solitary confinement. They found that solitary confinement has devastating effects on youth, and that the youth civil rights that are being held out at Rikers, those youth, that their rights were being violated pursuant to the imposition of solitary and the conditions of confinement during that solitary confinement. And at that point, the New York State Advisory Committee recommended the Department of Justice take action and recommended the elimination of punitive segregation, actually up to the age of 25. Now, during the Board of Correction rulemaking at the end of December and early January, before we passed the rules, Commissioner Pond had agreed to end punitive segregation for the 16 to 21-year-old cohort, but needed additional resources for the 18 to 21-year-olds. So the board provided the year to obtain those resources, and based on variances that have been sought, provided another half a year. My opinion, he appears to have the resources that he would need to be able to end solitary confinement. Commissioner Pond also requested a regulation to create a young adult housing cohort that was 18 to 21, because he's very mindful and very committed to this age cohort to try to better meet their needs and have a better chance of turning their lives around. A year and a half later, after these regs, we find ourselves in the position of having 3 variances to entertain regarding the young adult plan. Before I call the commissioner up to explain to us the revised young adult plan, as well as to discuss some of the changed circumstances, I do feel it's very important to note Commissioner Ponce and the Department of Corrections' successes here. He has successfully ended punitive segregation for 16 to 18-year-olds. He has undoubtedly improved the conditions of confinement overall for the 16 to 21-year-old age cohort, and that includes incentive programs, more access to education, more programming, alternative discipline, alternative housing to punitive segregation, and a dramatic reduction in punitive segregation of those 19 to 21. His success also includes much better training of the officers, including direct supervision, engagement of the officers, and I see many of the leadership of the Department of Correction Young Adult Plan, active engagement by the leadership out in the jails, which has really helped to bring about a lot of the success that we've seen. And we have, notwithstanding the uptick recently, there has been a reduction in general with the use of force and the violence. So there have been successes. At this time, I'd like to call up Commissioner Pond to provide an update as to exactly where we are with the young adult plan and be able to answer any board questions before we proceed to entertain the variances.
Oh, good morning. It's a pleasure to be here to give you a kind of a brief overview on where we've been, what we've done for the last couple of years. As Judge has mentioned, that we have much of the leadership from the agency here, much of the leadership who have been part of the changes in the organization. So a little bit of factual information. So in December of 2014, we ended punitive seg for 16 and 17-year-olds. That was not a regulation, that was not a rule. We ended all historic time. That was a process of inmates getting out, coming back into the system, getting put back in segregation based on time. So we did those things prior to any rule. So while I agree there was issues with the use or overuse of punitive seg, as pointed out in the DOJ investigation, we clearly took action in a fairly short span of time. Now, I know in the transition that other agencies have gone through, specifically juvenile justice agencies, that have transformed themselves from overuse of punitive cell, segregation, overuse of lockdowns. The time frame was about 10 years. So it took 10 years of kind of trial and error of people trying different things to eventually get to a point where punitive segregation, or even segregation to any level, was just about eliminated. So we've worked very hard in the last couple of years on reducing punitive seg. And I know, well, from the outside, people may say, well, you haven't done enough and you haven't gone fast enough. I really believe if anyone's run large organization like we are in New York City, that we've really moved with lightning speed. So in January, we had 190 young adults in punitive seg. As of today, I believe the number is 15 or 16. So we've done some great work. I won't back away from that. Clearly, as we look for variances and changes to the timelines, I think clearly the work that's been done is really historic. As I said to a few of the board members yesterday, if you can give me the names of any other agency in the country, anywhere in the country that's done something even close to what we've accomplished here, I want to go look at them, because no one's even talking about this, never mind doing it. So the time that we're asking for, the time we're looking for it in order to build both the compliance from how do you do it, the skills in our staff, but also the physical plan changes. Now as you pointed out, we wanted to start secure in conjunction with punitive seg. So we'd have both for a period of time and kind of move off of one into the other. As you know, through some fault of our own and some not, we did not start that program until right, I think, 3 days before punitive seg was to end. So it really was my decision as I looked at incidents as they evolved over time, and we really pushed to that final date. I felt that we needed to hold everyone's feet to the fire, so to speak, to really see if we could really do that, and then what were the outcomes. Safety has to be the prime factor that we all agree on. Safety of staff, safety of inmates. If we can't provide a safe environment, we literally can't do anything. Programs don't work, staff don't function very well, the outcomes that we hope to achieve don't happen in the organization. So good programs in an unsafe environment just do not work. So as we move forward and built the skill level of our staff, we encountered some things in GMDC that we've never done before. We added 160 brand new officers to the TO. Why? Because we're increasing the staff to inmate ratio in that building. The problem is that we've never onboarded 160 new officers any time in our history, and specifically in one building, and then hope that they had the skills to deal with a very challenging population. We were doing fine. So one of the questions we have is, well, why did you wait a week or two before? And the reality was that we were doing fine in GMDC, and we have the leadership here, up until the first week in June. As we started to add more problematic inmates, or inmates with a higher risk, into that population, it started to disrupt everything. So as the judge pointed out, we weren't doing things and programs for other inmates in the same building that weren't causing us problems because of the problems and alarms that we were responding to. So it really was, the drive to push to the envelope to the end to say, look, I'm not going to take my foot off the gas until I'm convinced that we would cause more harm to continue than to delay. And that's really where my decision-making came in place, to say, if we continue down that path, we would have caused more harm. we probably would have had the possibility to undo many of the things that we have done. So it's not a union issue, it's not an issue that it's a safety issue. So how do we keep staff safe? How do we get staff buy-in rather than trying to force people to do something to convince them it's the right thing to do? We did that in RNDC. You can go in RNDC today, most of your staff are going to talk about the right way to manage inmates. In GMDC, we've gone a long ways. Different cohort, many more. So 1,000 inmates in comparison to about 180 young adults. I want the chief to just to briefly talk about what they did in those couple weeks to get safety back under control so we could then move ahead. So, Chief? Good.
Yes, good morning. As the commissioner said, we were doing fairly well at GMDC when we started to implement this young adult plan. We had introduced about 700 young adults into GMDC, and on May 27th, we started to increase the high custody individuals into the facility. Then about the first week of June, we started to see incidents started to increase in the facility. And then continued on, we figured maybe just anomaly, some guys coming in, impacting the population, so we draw in some more individuals, and the incidents continued to increase. And that's where you see, Judge, where you said that programs started to fall down, clinic appointments were missed, mental health appointments. So the facility was responding to alarms at a rates of almost, the high was 26 in one particular day, so that's more than 1 an hour. So we all know who have been in facilities, when we have alarms and we suit up staff, the facility shuts entirely down, okay? And then we have to deal with that one incident. So usually it's about, 10 to 20 minutes, depending on what the type of incident is. So now to have 26 of these in any one particular day, nothing will happen. The entire system comes to a screeching halt. So we had collectively gotten together to see what we could come up with to assist the staff at GMDC, because what was happening was that now you have staff responding to alarms, suiting up all day. They just have this feeling of despair that nothing is going to get done because all we're doing is going down the hallway, suiting up to deal with inmates who are being disruptive. So that starts to eat at their psyche. They just, start feeling that there's nothing that they can do to get this under control. So we had to slow everything down at GMDC, come together collectively, and come up with a plan to put the facility back on track. So, and we appointed Bureau Chief Canty to oversee directly. We took her out of what was her responsibility at the time of management and planning, and told her, stop doing all of that, and we want you to focus directly on GMDC. Your job will be only GMDC, to be in there on a daily basis to assist the facility in gaining compliance. So I'll let Chief Canty step in and let her see what she had implemented.
Excuse me. Good morning. So as a result of all of the things that were going on in the facility, we implemented some things. So we started out with all of the chiefs, the wardens, deputy wardens, department-wide were tasked with going to GMDC 5 to 1, 1 to 9, from lockout to lock-in, to conduct status reports. They did tours, and they wrote up status reports on the status of the facility. Those reports we found to be extremely helpful, because what it did was it gave us a breakdown of all the deficiencies. Due to the fact that the facility was always in alarm status, so many things were being neglected, as the chief said. So it was sanitation, medical services, recreation services, including the lockdowns. So what we started immediately was, if you notice, we haven't had any facility lockdowns. We've had area lockdowns. So that was one of the first things that we talked about and tackling, was that we don't need to lock down the whole building in order to address the specific area. So that was one of the things we did. We implemented, ESU was assigned to the facility to assist with responding to the alarms, just to take some of the pressure off of the facility-based staff. The ability to transfer inmates out of the facility. They created a young adult housing area, an AMKC, and between attrition and transfers out, we've transferred approximately 76 inmates out of the building. We changed the role of Deputy Warden in Command Brantley. Now she's more involved in the day-to-day operations, and She was assigned new unit managers who received some unit management training, and she's over the day-to-day true and shoe units, just to make sure everything is going well in those units. In regards to the 160 newly assigned staff that we have, we came up with mentors for them to help them acclimate to the facility. That staff is assigned 5 to 1, 1 to 9, 11 to 7. We started out in the problematic areas just to make sure that the staff are comfortable. We've come up with just some suggestions in regard to the day-to-day the activities on the unit, just to help them acclimate. And then lastly, we noticed that, like the chief said, 20% of our incidents were from high-risk inmates. 36% of them were inmates who were formerly in TRU, and 20% of the incidents involved inmates and gang activity and classification. So what also was implemented was custody management at OSIU. They placed individuals in the facility so that we could do daily classification assessments in order to make sure that the housing areas were balanced, so that this way we could work in a direction to remove the violence.
Just to finish here, the issue for us that we needed to develop quickly some broad range options on how to manage this more difficult population. We've now have the census and young adults and GMDC kind of back to what it was. Their alarms per day, while a little high, much better than they were. So we're getting some normalcy to the program and the operation, which we'll need to move forward. The secure unit is now in our 3rd week of operation. We want to see that run for some time to get confidence in our staff that the unit will work as designed. And again, I encourage those of you who have been through the secure unit prior to opening, I encourage you to come back, look at it today, and again, hold our feet to the fire if you believe it's something that you do not think is working. I think it's been very effective. So I think as we looked at the GMDC plan or the young adult plan, if there's one thing that's clear is that we really expected too much too soon. We did not have enough of skill building of our staff. We did not have enough mentors, in a sense, for the 160 brand new officers. So all of those things were problematic. Maybe one of them could have been overcome, but all of them together really put us in a situation that was dangerous and unpredictable. We had to make the place safe in order to move the programs forward. And that's what we've done. The physical plant, we checked one day in GMDC a couple weeks ago, and 108 of the cell doors were inoperable out of a place that's about 1,000 beds. I mean, so the physical plant's been an issue for us also. Having the ability to secure inmates in cells, in day rooms, on tiers was always a challenge. So we're committed to everything we've said we were going to do. We believe that we'll continue to work closely with the board. We'll ask the board to support our variance request because I believe it's what's necessary to move us in a place that no one in the country has ever been. No Department of Correction, no jail system is even talking about this, never mind doing it. We came very, very close. So we need to devise a way to manage the more problematic inmates so we can then manage these other inmates in the fashion as we envision. No punitive seg. We ended punitive seg for 18-year-olds a month early. So there's been no 18-year-olds in punitive seg since the entire month of June. So we're committed to what we said. We're not trying to push things down the road. It's real. So safety of staff and inmates are real. We have to take that factor into consideration as we move forward. Staffs are not going to work for us if the conditions are unsafe. Inmates will not participate in programs if the facility is unsafe. So it has to be a good balance, and that's what we're asking for in this variance to strike that good balance. So I'll answer any questions the board has.
I know you've always said that you wanted to be able to run
So as you pointed out, there was substantial opposition to Secure. So we didn't want to build on a failure. So we were a little cautious putting the first 3 in. We have 4, I believe, going in today. So some of those will come from punitive SEG. We're trying to build on success. The unit operates as a result of the skill of our staff. It's not the physical plan. In fact, I think most of us don't like the physical plan, but it really operates on the success of our staff and the skills that they will develop in time. And so I think slower, having good, I mean, knock on wood, for the first couple of weeks, that unit has operated well beyond any expectations. I mean, they really have. Inmates came into that unit wanting to participate. They didn't come in, we didn't kind of drag them in and say, you got to be here. They wanted to be there. That was a great outcome based on staff's ability to talk inmates into why this was important to them and what we were going to offer them in the way of the program. That was just a great outcome.
Other questions?
I have a question about enhanced supervision. I know as we've been going through the young adult plan, you and I had talked about it. The board gave you enhanced supervision at the same time that we started dramatically reducing the use of punitive segregation. And I know up until at least yesterday, you had not wanted to use enhanced supervision for the young adults. You and I had discussions. I thought it might actually be a good tool while we try to reduce punitive seg, because Secure is just sort of kind of a tweaking of enhanced supervision for the young adults. Can you just tell us why you think now enhanced supervision would be a good tool to use while you try to reduce reliance on punitive seg?
I think my reservations about not using it was mixing young offenders with more experienced criminals is always never a good idea. Well, it may keep the pressure down, so to speak, but it's also a bad idea because those are the adult prisoners that have caused a lot of violence in our jails. So mixing them together conceptually didn't seem right. And the kinds of programs that work with young people, we don't offer it in enhanced supervision at this point, so we have to change the programming to a degree. But I think conceptually, given where we are today, obviously something that we want to explore.
And in the enhanced supervision, should that hearing be granted, is your plan to have a separate, because I know originally you could go 5 enhanced supervisions. You have less than that. Is your plan to have one just for young adults or mix them in with the other adults?
Depending on who the adults are, we may do some small mixing, but the programs that impact young people have to be delivered there in the ESA. So in the beginning, we may have to mix. I think down the road, it's nice to have units that are separated for young adults.
Other questions?
Just a comment. I guess the struggle for me is the basis for creating Secure and the young adult plan was that would be an option for managing inmates who committed serious infractions. And so what I'm struggling with is what changed? Do you now believe that Secure is not a viable option to manage inmates? And if it's not, why are we moving forward with that kind of plan? And if it is, then why don't we look to move people into Secure if they infract, if that's the program we believe is for them? Why don't we move people in there if they infract, and if it doesn't work well, be able to then have the option to move them into punitive seg? Why are we leading with keeping punitive seg instead of moving forward with Secure, and if the option, if Secure doesn't work, to move them into punitive seg?
Because I think we're looking for good outcomes in the beginning to develop the confidence in our staff. And that's why the cautious is 3 inmates the first, I think as I just said, we had probably about 30 staff in there at the time, just walking around and figuring out how things were going to run. So it's trying to build the confidence in the staff to be able to do that rather than just say, okay, like you're taking anybody today. And it is a bit of a selling. I mean, it is a bit of convincing staff this will work. We're asking people and our officers and non-uniform staff to buy something they've never seen. I mean, it doesn't exist anywhere. So we're telling you this model will work under these conditions, that we have to prove it to them. And I think that's a fair request from them. Prove to me this works, and I'll be safe. And that's what we've done in the last couple of weeks. We believe we'll continue to do that, to the point, you're right, when somebody infracts, that's where they're supposed to go. Absolutely. At 18-year-olds now, that's the only place they can go.
Right.
So.
Others, comments or questions? So first, I'd like to thank the Commissioner and the Department for responding, albeit late before our meeting, and we will be handling each of the variance submissions separately in a moment. But since we received the variances, the staff of the board has fashioned and shared individually with members of the board, has fashioned conditions which we will be making public in a moment that we would like the department to look at, consider, and respond to us. So I'm going to recess for 10 minutes and let the department review the conditions which the staff has distributed. Derek? So we're reconvening. I thank you all for your patience and forbearance. At this moment, we have 3 variance requests before us. We're going to handle them one at a time, and the board is considering, in conjunction with each of those variances, conditions to be applied to the variances, and we will read aloud, take a few minutes for each of the variances, those conditions. The department has seen them, but this will be another opportunity for them to ask questions of the board in regard to the proposed conditions. Once they're read, we will treat each of the variances as an action item for the board that will have to be moved and seconded with the conditions, and then through the normal process of discussion and voting. So let's begin with the first variance, which goes to commingling.
Good morning. The Department of Correction is seeking a limited variance from Board of Correction Standard 116C1II, which requires that as of January 1st, 2016, inmates ages 18 to 21 years old be excluded from placement in enhanced supervision housing until October 11, 2016. While the scope of the BOC minimum standard is applicable to young adults ages 18 to 21, the required variance would only be applicable to inmates ages 19 to 21 years old.
Now the conditions. Okay. So there are no conditions on commingling. So could I have someone move this variance request and second it so we can have discussion?
That's not what you read.
Sorry. Yeah. Well, can we do enhanced supervision first? Okay. So, could I have
We do have conditions on ESH.
We do have conditions on
Do you want to go through them?
I would like to go through, hold on the motion, because the conditions ought to be read into the record, and so the process would then have the variance incorporate the conditions when we move and second.
So I'm going to read through 3 conditions on ESH. The first, during the pendency of this variance, each request for approval of a placement of a young adult into into enhanced supervision housing must be in writing and specify the reason why a less restrictive housing setting is not a safe option. The chief of department must also specify his reason for approving the request. The request for approval and the chief's approval thereof shall be sent immediately to the inmate who is the subject of the request, New York City Health and Hospitals Corporation, or Health and Hospitals, and the board. I'll move on to the second condition. During the pendency of this variance, the department shall provide the board with a weekly public report of implementation of the foregoing conditions, which shall include the following information. A, the daily number of young adults held in punitive segregation, secure unit, SHU, TRU, and ESH, and the number of young adults released from each of these housing units. B, for each punitive segregation sentence, the rule, I'm going to continue, that's correct. The rule violation, whether the sentence was approved or disapproved by the chief of department, and the type of housing unit in which the inmate was housed at the time of alleged rule violation, e.g., GP, SHU, TRU, secure, ESH. C, for each punitive segregation sentence the chief of department reviewed 15 days after commencement, whether an inmate was placed in an alternative housing unit for the remainder of the sentence, and if so, where. D, for each young adult released from punitive segregation at the end of his full sentence, the housing unit, e.g., GP, SHU, TRU, secure, ESH, into which the young adult was transferred. E, the daily number of young adults in punitive segregation who were offered 2 hours of recreation, and the daily number of such inmates who accepted 2 hours of recreation. F, the daily number of young adults in punitive segregation who were offered 3 hours of recreation, and the number of such inmates who accepted 3 hours of recreation. G, the daily number of young adults in punitive segregation who were offered 2.5 hours of programming when that's available, and the number of such inmates who accepted such programming. H, a weekly young adult census showing in which housing units and jails young adults are housed. I, a weekly summary of young adults admitted to TRU, SHU, secure unit, or ESH, collectively PS alternatives. The summary shall include 1, the number and percentage of young adults in punitive segregation alternatives who had a previous placement in TRU, SHU, or the secure unit, followed by a placement in general population housing or any housing other than a step down from TRU or secure unit during their current incarceration. 2, the number and percentage of young adults in each PS alternative or in punitive segregation who received a timely case review and a timely determination as to whether they would remain or be transferred out. Timeliness is determined by the periodicity of reviews and determinations set forth in the relevant department directive or draft directive. And 3, the number and percentage of young adults transferred from each PS alternative following a case review. And J, a plan and timeline detailing steps and benchmarks necessary to end punitive segregation for young adults. The department shall provide the board with its first weekly report by July 19th, 2016, and shall provide a weekly report thereafter on the second business day of the following week. The third condition on the ESH variance is that on a weekly basis, the department shall provide to the board notification and review paperwork of young adults admitted to TRU, SHU, secure unit, and ESH.
With the, well, I'm going to do this as if it's a motion, and then we'll have discussion and questions. So could I get a motion on the variance with the conditions attached? Is it moved and seconded? Okay, so the item is open for discussion. Bobby, you want to?
There's a question on that. If someone has a sentence to 20 days, they will go to ESH and then they can get released, at a maximum of 20 days? Because currently ESH is what you don't get out of ESH unless you get out of ESH. There's no.
I'm not sure where you're getting the 20 days from.
Because we're talking about people who are in punitive segregation. They've been in punitive segregation because they've been sentenced to some time in punitive segregation.
Okay.
And those people are going to be taken out of punitive segregation and perhaps placed in ESH. Are they going to be placed in ESH to serve the rest of their term, or are they being placed in ESH under
I think
Are you
that's a
talking
question
about
for the
today?
department, right? Yeah, why don't we just ask the department?
Okay, I guess it's your proposal.
So any individual that is removed from punitive segregation, their time stops, so they don't serve time anywhere else other than in punitive segregation. So the answer is no.
So just so we understand, so the purpose in asking for the variance for enhanced supervision is so that you have an alternative.
That's correct.
To punitive seg, so you as chief who will have to approve places in punitive seg, you might determine there's a least restrictive setting available, that being enhanced supervision, but it's not to serve punitive seg time. It will be based on the due process requirements for enhanced supervision. Is that correct?
That's correct.
And similarly, when this variance expires, then these people will be released to the general population.
Secure, second chance, or
They
true.
will not be kept in the SH at that
If the variance ends, then no.
point. Yes.
Other questions?
Actually, just because of the variance timing, currently the ESH variance we've asked for is 3 months with an assessment period for what that is. So generally the variance goes away for both PSEG and ESH.
And solitary confinement for a
Yes.
22-year-old next year. Then this ESH variance will also end for the under 22s?
Yes, I mean the current variance is both for 3 months.
But, I'm not sure I'm following the question, really. Are you,
Yes.
is this ESH as a tool for the population? Are you asking that?
I mean, the board has a meeting.
So-
We discussed, them using ESH as a way to avoid 23-hour watches in the population while you're ending solitary confinement for people under 22. So, and you're planning on doing that, right? You're going to be ending solitary confinement.
Yes.
So should you end that in 2 months, then at that point, people who are people under 22 do not have to be in the, should not be in the
No,
ESH.
so if they are actually, if we prove that ESH is actually a viable alternative, it works, and it increases security in a less restrictive manner, then we would maintain that. And then we would talk to you about.
On an individual basis,
Yeah.
right? That's what I,
Well, I think this is more restrictive than secure. This is 7 hours rather than 10 hours.
Yes.
And I don't think the board is interested in people not being in for 23 hours right now, the way you're currently expanding solitary confinement. You're putting people in for 23 hours a day. Maybe we'll get something better by the end of this meeting. But our concern about allowing ESH for this population is to help you in the short period of time now and when you end ESH to have have people get 7 hours of time half a day. But when you end solitary confinement for people under 22, they should not be in ESH and
because there'll be another alternative
Yes, I just
available.
want to clarify that that's
So, but that's the tail end of the question, though. The expectation is when they end it, there'll be other alternatives, and other than ESH is what
yes,
you're,
it'll be true.
yeah.
But I think part of what we have done, and I think as the judge kind of mentioned, we are trying to figure out what the scope of options are that will allow us to safely manage some of our more violent kind of inmates in the young adult population without using punitive segregation. We are currently in the process of assessing each of those options. Some of those have proven to work a bit better than others. As we identified in our letter, 36% of the incidences that occur were actually people that came out of TRUE. So we have to reassess exactly how TRUE is working. Similarly, while we do this with ESH, we will be assessing the effectiveness of ESH as an alternative. If it's something that actually is useful, especially for a certain population, we will talk to the board about it, as I think the judge asked us to do.
So just so we can clarify it this time, you came to us and asked us for the variance for secure because you needed secure to be able to end punitive segregation, correct?
Yes.
And then it seems fair to say, given certainly the physical appearances of secure, perhaps as well as some of the policy and protocols that were developed that you eight inmates in sort of a small cage day room with one, that you might want to revisit that. And in the meantime, it sounds like you would like to have enhanced supervision as an option, even though it's further along, and it certainly right?
That's correct.
In other words, you're not telling us you're going to end enhanced supervision when you end
No.
That's separately received and independent.
That's right. That's right.
And that's because of the revisiting as to whether enhanced supervision might not in fact have been
That's right.
a useful tool to maintain violence.
Yes.
And subject to discussion during the time frames that are outlined in the variance and so on. So there'll be an opportunity to interact on the efficacy and value of ESH.
Yes.
Find it hard to understand how we and the board have been discussing a program around true, second chance, secure, with a limit of 10 hours and then going up to 14 hours. And now, we agreed to discuss ESH because we think 7 hours out of cell is better than no hours out of cell, which is the current situation for most of the people in prison segregation. So it's 94% of them don't go to recreation. So you're just locking people up for 24 hours. We thought temporarily, until you end solitary confinement for those under 22, that it would be better for them to have 7 hours out of cell. But I don't think the board wants to continue a program where we're going to agree to have people with only 7 hours of cell who are young adults.
So we're going to have another bite of this apple during this period. The point is made about the 7 hours, and the department is now aware that the board will be very focused on the value of ESH as one of the alternatives. The case will have to be made and subject to our valuation of it as an alternative against the obvious goal of increasing the amount of time out of cell. Okay?
So this is very time-limited variance so that we can see how it actually is used. It appears to be appropriate and effective, and that's why we would be requiring the chief's approval. If the chief's not available, then I would suggest it should be a commissioner's approval and no other designation.
I think possible, just given both schedules, if a bureau chief designee would be appropriate, but we'd like to ask for that designee.
Okay, any other questions or comments?
How long is this variance for? Pretty much.
I'm going to call the question. All those in favor signify by raising your hand. I will see you. I think that's everyone. So the motion, the variance with conditions passes, and we can move on to the second one, which will be commingling.
So on June 30th, the department submitted a request for 2 limited 6-month variances pursuant to 115B of the New York City Board of Correction minimum standards. First from 102C1, which as of July 12th requires inmates ages 18 to 21 be housed separately and apart from inmates over the age of 21. This limited 6 months variance request to allow the department to commingle 19 to 21-year-old inmates with inmates that are 22 years and older.
So we need a motion. It's moved. Second. Seconded. Questions or comments?
I have some questions. Is the basis for this request is as you try to consolidate all the young adults in GMDC other than secure, you have found that it's potentially a too explosive situation to have all the young adults housed in one jail? Is that the reason for it, or is it that, and/or
I don't believe we want to revisit the young adult plan. It says what we said earlier about the challenges that we faced at GMDC with bringing individuals in.
So I think we do need to look at how to manage that higher risk population. That what we had in place in GMDC was working fine up to about 750. So where to put them in the physical plan in GM, the doors and stuff are not as security at other places. So when we say we're going to have to relook at the plan, we know where we want to go. It says where do we house them, in what numbers, and in what programs.
So, good morning, everyone. I wanted to provide a little context to the conversation that we've had. And first and foremost, I just wanted to remind everyone here that the decision to end punitive SEG for 16 to 21-year-olds was made by the department's executive leadership. And so, although the public and many of our stakeholders are disappointed, so are we. We did not meet our own goal. It is of my opinion that we already did it in December 2014 for 16 and 17-year-olds. We did it again in June 2016 for 18-year-olds, and it is of my opinion that we will do it for 19 to 21-year-olds. We just need the time to develop safety precautions and protocols for some of the unexpected things that have come up, a lot of unintended consequences that we've seen, although there was a lot of good intention. I also wanted to say that I know that many of you are looking at that 6-month time frame as being a really long time, but as I was thinking through, what have we accomplished over this 6-month period, I recognized there were so many things that I think that I just wanted to bring to light. And so one is, again, I think this truly reflects our deep commitment to our 14-point anti-violence reform agenda, which includes our adolescent and young adult reform strategy. Although we've been experiencing a number of challenges, we have really experienced a great deal of achievements as well. And I just started to list them because within a 6-month period, we provided approximately 550 young adults with consistent programming 5 days a week. We developed alternatives for punitive SEG, True, Second Chance, and Secure. And I know that, many of us view 36% as being a failure. I actually don't. It is a pilot. And we are aware that this is not a one-size-fits-all solution for the diverse youth population that we service. In addition, in this 6-month time period, we also utilized technology to advance education and idleness reduction efforts. We developed a reentry plan for 18 to 21-year-olds who don't meet the criteria for ICANN. We constructed space to provide programming, our Peace Center, which is our programs, education, and community engagement space, and also the facilities hobby room. In addition to that, we integrated violence intervention prevention services to address gang-affiliated youth. In January 2016, we had approximately 100 young people in punitive SEG, and today we have less than 20. The largest number of officers placed in any one facility was the facility that we designated as our young adult facility. We have never done that in the history of the department. In June 2016 alone, in 1 month, young adults have received 288 certifications in the areas of CPR, food handler certification, OSHA scaffolding, OSHA 10, OSHA 30. I mean, we also saw our first valedictorian. We had one youth who became the valedictorian who was also a primary trainer in our Rikers Rovers program for over the last 9 months. So I think that I just wanted to remind everyone here, this is our goal, and we are also disappointed, and we certainly wouldn't be sitting up here if we thought we could do it safely. For the first time in history, I've been at the department for almost 10 years, I get calls from parents saying, thank you for keeping my child safe. Thank you for making sure that my child went straight from RNDC into GMDC program house. Thank you for noticing that he had a problem with XYZ. And so I just wanted to say that I needed to say that so that we can all be reminded of what has been done. And the programming strategy is being worked on so that we can make sure that we infuse evidence-based programming. At the end of June, our program counselors and select officers received DBT training, received non-coercive approaches to reducing conflict, and a number of different training that can provide tools for managing this population. So I just want to say that I'm asking for your continued support and patience as we move forward in this endeavor. But this is certainly something that we want to do for the department and for the public at large.
Any other questions or comments on the commingling?
I have the pleasure of working personally with Lynette Saunders and the whole leadership team on the young adult plan, and much of what she's reported I have in fact seen and witnessed firsthand. It's most regrettable that as we tried to move in the high classification, maybe there wasn't enough work on it, managing skills to be able to do it successfully. But it does appear to me that 6 months would be a reasonable extension on the commingling. Also, I note that the regs do not require consolidation in one jail. It's just young adult housing. There had always been initially the plan was GRBC, where there's programming and educational space, and GRBC. And I know some of the consultants that are working with the department have specifically advised that not all young adults, especially the more challenging and difficult to manage, that they should not be placed in GRBC because they may be responsible for a lot of lockdowns that will interfere with the program and with the rest of the young adults. So I think it's very reasonable.
Any other comments? I'm going to call
I've been very impressed with the work that you've done and your staff and everyone within the GMC. I don't think our concerns were about the failures of your programs up through a certain moment. Our concern, and I really haven't heard anything yet today to assuage us, is why it collapsed in June. Why at that point you stopped providing medical services, you stopped providing mental health services, you stopped providing law, library, recreation, all the things that happened, and why you set up a special secret unit for interrogation where people are currently staying without mattresses. And so, things really went downhill over the past period. But I strongly endorse what you're saying. And maybe since you're looking at the program, can you explain why there is a special interrogation unit that the departments, the health, hospitals and the board, we're not informed about, where people are staying without mattresses, have no mattresses, up until the board went there multiple times, had no running water.
So I'm going to...
It's a special, as I understand it, it's a special interrogation unit that is using in addition to intake.
So if you can enlighten me, Bobby, because I'm unaware of any special interrogation unit.
What did you call it, Jeff? You called it special?
Sorry, so we set up an overflow for the intake area at 3 Upper A.
Yeah.
Yes.
So if that's what you 3 Upper A at GMDC?
3 Upper A, which Jeffrey described to us as a special unit for an interrogation.
It's not a housing unit. It's
So what we found at GMDC for the month of June with the alarms that we were having. So, excuse me, back up. So the GMDC intake is insufficient for the size of the facility as is now, the way it was originally designed. So we added a modular intake to accommodate that overflow at GMDC. But during the month of June, with the amount of alarms that we were having and the disruptive inmates in the housing units that were coming down, we were just exacerbating the problem by keeping individuals in the intake that necessarily didn't belong in the intake. So we looked at areas in the facility where we could, similar to what we have at GRVC and OBCC, is intakes that are not your traditional intakes. So we designated 3 Upper A at GMDC to be that overflow unit, where instead of taking inmates to the intake where they don't belong because they're not leaving the building, right, or they're not necessarily getting rehoused at the moment, they don't need to go to the clinic, we're putting them in 3 Upper A so we can have movement assess where they properly belong because of the problem that they were just involved in, and then we're taking those individuals from there and allowing them to go to other housing units without disrupting our court production, clinic production, or specialty clinic production off island in the intake.
Why do you not, people stay many hours in this unit, people stay overnight in this unit.
No, they don't stay overnight, Bobby. They may be there at overnight hours, but they're not sleeping there overnight. So depending on the time of the incident in which they were brought there, the area is emptied out every 3 hours, okay?
There are beds without mattresses, there's no place.
Right, because we're not using it as a housing unit, so, and no intake is there a mattress.
The toilets were not available to people, the water was not available to people.
So we have a I'm not going to argue the point with you, right? You were there, if the water was off, we have a policy on when and how staff can and can't turn off the water. If they turn it off, that it has to be immediately put back on once the individual who caused a flooding condition is removed from that area. So we're not going to allow the water to stay on while someone is causing a flooding condition and allow the whole unit to just get disrupted because of a flood. We have to go in and turn, I'm sorry?
I'm sorry, it was our understanding based upon staff visiting the place that for days, water was not available to people, that people were sleeping in that area and no mattresses were available.
So yes, there is no mattresses in the unit. It is not a housing area. It's not intended for people to go there and go to sleep.
The water was off, but we rectified the situation when I was there a few days ago.
Well, I'm just explaining to you that we have a policy that we do turn the water off on occasion.
Which I was aware of and which we discussed with staff. I mean, I think the issue was more about why we had to go and discover that the water was out so that the water would be turned off and what the chain of command was and who was accountable to make those decisions to keep the water on or off, which we had to spend a long time trying to figure out when we were at the unit. And Chief Canty sent a team, and that was great, and they cleaned up the unit and did some work. But obviously the board members have a lot of concerns about what we've seen in those days and who, the oversight of that unit.
Other questions or comments? Then I'm going to call the question on the commingling variance. All those in favor, signify by raising your hand. Motion carries unanimously. None opposed. Now we're going to move to the third variance request, which does have conditions. And we're going to once again read those conditions aloud.
We present the variance first.
Sure.
So the second of these two variances that I'm reading is from Board of Corrections Standard 117B1II, which requires as of June 30th, 2016, the exclusion of inmates ages 18 to 21 from punitive segregation. Based on our ongoing assessment, we are modifying the original 6-month variance request from 117B1II to a shortened period of until October 11, 2016, at which time we'll report back to the board on the progress made and the next steps in eliminating punitive segregation for this population. The requested variance will remain applicable to young adults ages 19 to 21 years old exclusively.
Thank you. And now the conditions that the board wishes to apply.
This is where it's going to get messy, but I hope not. I'm going to start with the first condition on that variance. By 5 p.m. should this pass, by 5 p.m. on July 13th, 2016, the department shall review each young adult held in punitive segregation and shall transfer to alternative housing units those who are in punitive segregation for infractions other than infractions for A, slashing or stabbing of staff or other assault on staff that causes staff to suffer one or more serious injuries, or B, a slashing or stabbing of another inmate. 2, during the pendency of this variance, each request for approval of a sentence to punitive segregation must be in writing and specify the reason why a less restrictive housing setting is not a safe option. The chief of department must also specify his reason for approving the request. The request for approval and the chief's approval thereof shall be sent immediately to the inmate who is the subject of the request, New York City Health and Hospitals, and the board. 3, during the pendency of this variance, a young adult shall not be held in punitive segregation for more than 30 consecutive days, nor held in punitive segregation for more than a total of 60 days within any 6-month period. A young adult who has served 30 consecutive days in punitive segregation shall be released from punitive segregation for at least 7 days before that inmate can be returned to punitive segregation. 4, during the pendency of this variance, whenever 15 consecutive days of a young adult's time in punitive segregation has elapsed, the Chief of Department shall complete a review of the inmate's time served on the 15th day to determine whether the inmate can be safely placed in an alternative housing unit for the remainder of the sentence the inmate is serving. The decision and the reasoning supporting it shall be stated in writing and immediately sent to the inmate, the board, and H&H. 5, by September 6, 2016, the department shall report to the board in writing whether DOC is on track to end punitive segregation for young adults by October 12, 2016, and the benchmarks it has met and may still need to meet in order to end punitive segregation. And then we get to the last condition. Do you want to say something on that condition? We're incorporating by reference all of the reporting requirements that were attached to the ESH variance to this variance. It's the same as what I read earlier. There's one more condition which I will start with, and I don't believe that I have it in the way that the board members have discussed. So please correct. All 19, this is the last condition on the punitive segregation variance, all 19 to 21-year-old prisoners confined in solitary confinement be provided with the option to lock out for at least 4 hours per day in an adequately sized area of the large OBCC young adult PSU housing block. This out of cell time would be, and then I don't know where we are.
So I believe that for
Can we
this
start with that
period-
sentence? And
I believe for this period, the 2.5 hours would be included with an eye toward that growing as the capacity band.
Yeah, those 4 hours of out of a cell will include 2.5 hours of programming once program is up and running, but these 4 hours start immediately. It's separate from the 2.5 hour rec.
So to clarify,
But I also want the department to have a chance to respond, to talk about it.
We can't do it immediately.
So you,
Can't do it immediately.
department now, you've heard what was just articulated. Comment, if you will.
So, in terms of the request, we believe we can come to agreement on a plan to get that there, but it will not be immediate. We would have to construct a physical structure to allow for the safe movement and allow for especially any separation issues that we have to maintain. Most of these people who have been involved in the slashings and fights have previous conflict issues, and so physically, as just a timing issue during the day, the current young adult punitive segregation space has a very small day room in the back and a middle area. Any movement that goes along for showers, visits, or other things would entail a restrained inmate walking to wherever they're going, while potentially in this option, unrestrained inmates are in that area. And we have seen several accounts of dramatically bad outcomes. One of the huge fights that occurred in GMDC was when they restrained an inmate to move him out, and everyone saw that as an opportunity to attack that inmate. And we can't do that with full 4 hours for all that immediately. What we would propose was giving us 30 days to construct an opportunity, construct an area by which we can then allow for inmates to be unrestrained and for that lockout area, but in an immediate sense, we couldn't do it.
So it'll take you 30 days to get to the 4 hours of programming out of cell time.
And then the lockout. So a combination of both, because programming, we would offer 2.5 hours of programming, and which would be at desks, and then another 2 hours it would be. But that would, again, some deference to the kind of combination issues. Some commingling may be allowed, others may not.
That makes sense.
Please, just to explain why that would take 4 weeks rather than 2 weeks.
Because we have to physically construct an area.
No, I understand it takes time, but why would it take 4 weeks rather than 2 weeks?
Actually, and I'm also reminded, we have to get SCOC approval, which is on a monthly basis. I cannot construct without the SCOC approving, and they only meet monthly.
So we would like this as soon as possible.
Sure.
But we understand that there are things that have to be accomplished, and we will revisit it as we, at our next board meeting. Okay? Yes,
Yeah, I'd like
please.
to just ask a couple of questions. As you and I have been speaking, I'm really sort of constrained to find the justification to continue punitive segregation here. I know you certainly didn't advise us before. You haven't, in the 10 days that you went into violation, you haven't said, we have this specific individual that presents such safety and security concerns that we have to keep them in 23-hour lockout. Just one moment. We know you've created secure. You got a staff of 78 people with only 3 inmates. You'll now have enhanced supervision. One of the reasons we wrote and passed this reg pursuant to the CAPA is because we all know how harmful the extreme isolation is to young adults, not just physically, mentally, socially, developmentally. It impairs their well-being at the time, in their future. So what can you offer to mitigate the harm that we know accrues to the young adults locked in 23 hours a day, should we want to consider granting the variance? Because I haven't really heard anything then, if this is being modified.
So I think essentially what we've done is tried to modify, in which we offered this punitive segregation continuance, is to ensure that we can appropriately test the use of each of the alternatives that we've created and have never been done before. We have offered up the out of cell time, which is the main concern of the board. We agree. We are trying to do it in a safe measure and a balanced measure. We have offered 2 hours in rec, an extra hour if they, show good behavior and also participate in program. We've committed to offering 2.5 hours of congregate programming outside of their cells. These are things that would allow them out of the cells to mitigate some of the concerns that you've identified and that we also concern ourselves with, but at the same time would give us the time to continue to safely manage those people who are insecure and true. As I noted before, it isn't about an individual, but simply we did take statistics from the events that occurred at the beginning of June. If 36% of the incidences occurred with people who were in true and then released from true, potentially too early, into areas where they then conflicted with other people, that program may not have worked as well as we would have thought it would have been. It worked in the adolescent community, and we did a good job with that, but at the same time, we also experienced several spikes during the first 2 or 3 months after we actually established second chance and true. Here, we also, with a more violent population, statistically, and certainly with more separation issues, both by classification and by gang affiliation, we want to make sure we do this safely. And I think, as the Commissioner stated, we want to make sure we don't only do it safely for the inmates, we also do it for the staff. We are also trying to get the staff bought into how they need to actually interact with this population. So I think we've made a good faith effort in trying to lessen the issues in this punitive segregation for this population in order to get us closer to our ultimate goal.
So I have one last question. When we spoke last week, there were 7 young adults in punitive segregation. And I've seen over the course of the months, it's been dropping. And as of last week, all 7 of those could be safely transferred. Why do we now have, I believe yesterday you said we have 18 young adults. That's more than doubling the amount of young adults we have in punitive seg in less than a week. How did that occur?
So essentially, as we stated before, some of the incidents that occurred included people, a small population that actually had been involved in multiple incidences, whether it's people who were in true who would otherwise have gone into punitive seg, but we didn't. We put them into true, and then they came out and committed incidences. People, several people who were let out of punitive seg and then committed infractions. The new people who are in there are, as we explained to you yesterday, in terms of all the infractions, and a majority of those are slashings, including those who were actually in slashings after we moved some of the inmates out of GMDC into AMKC. Slashings occurred the first Monday after which we moved a population in there, and then the Monday after that, another slashing occurred with multiple people involved. So the number has fluctuated. It's never been about a specific individual. It's about trying to safely manage a potential cohort of individuals for which we don't necessarily have the best managed housing units right now.
Hey Jeff, can you describe, when you say safely manage, can you give some more content to what that's going to involve? When we heard earlier that the problem with implementing the end of punitive segregation right now, I think one point was made that the inmates were being disruptive. The other point that was made was there was a need to manage problematic inmates, neither of which is a great surprise at Rikers Island. So I'm just wondering what you are going to, because you're always going to have inmates who are disruptive.
Yeah.
And you're always going to have a need to manage inmates. So what are you going to do specifically in the time frame to get yourselves in a, talk about managing safely the transition. What specifically would you do in the time frame to get yourself in a position where you think you'd be comfortable ending punitive segregation for the 19 to 21-year-olds? Or is this going to be a continual conversation that we have every 3 months, every 6 months, with kind of no end to it?
Well, I think what we're trying to do is deal with, I think as the Commissioner stated, first and foremost, what has happened in RNDC, GRVC, places with the model facility. A huge effort was placed on empowering the officers to engage with the inmates in a different way, to make them comfortable, give them the training, give them the tools, but also make them comfortable in dealing with that population, whatever that special population was. In GRVC, the high-class population, in RNDC, the adolescents, in other units, kind of the mentally ill. Here we have another subsection of a population, the young adults, who have statistically been our most violent. One has to be to make sure that we empower and strengthen the skills of those officers. As the Commissioner stated, we had 160 new officers who came in, and that coincided with some of the issues that occurred within GMDC. So first and foremost. Second, we do have to evaluate the alternatives to punitive segregation that we have. We have set up and we modeled after what we did with the adolescents, but generally those are not things that are available to us in the nation for us to kind of send people out and just figure out whether or not it's a best practice. It's never been done before. So we have to evaluate whether or not it's working. And we have seen evidence, and as we kind of move this forward, some work, some didn't. We need to tailor that up, so we needed the time to kind of get there. I think to your broad point, I mean, I think Wynette did say it best. I'm certainly very disappointed myself, but at the same time, We are doing this as best as we can to kind of balance the safety on both the staff and the inmate side and make sure we have long-term, far-reaching success. And that's what we were asking for. I think the conversation about problematic inmates, violent inmates, will probably always continue. Not in a way that I think I'm telling you here that we're going to come back for another variance and we'll just keep, never mind, we'll take away, this, we'll continue PSEG, but in that this is a conversation that has to happen for any population.
And are you confident that you can get to a point you need to get to in 3 months?
Yes, I believe so.
Then why did you initially request a 6-month variance?
To give us time to, as we've said, to get everything set up and put everything in place. But now, we understand that we've asked now for the 3 months because it's true that that's all we were going to get if it is approved. All right, so, we're not going to continue to fight, we want 6, you want 3, so at least we can agree that if there is a number for approval, it'll be 3.
So what you originally needed 6 months for, you now think you can do in 3?
That's not it. If we had had the 6 months, it would probably been, I think the chief is, I think 6 months would have been prudent. We could have kind of spaced it out, been a little slower in kind of moving things forward. We do realize that the commingling is kind of a more important kind of management tool that will allow us to kind of do this. Some of the issues that we identified, as I tried to go through, statistically, there were issues with some of the alternatives in punitive seg, some of the high percentage of people concentrated in a small population. There were issues with classification, separation, and gang identification, which we've tried to solve in terms of identifying this daily high-risk group assessment. But the separation allows us some flexibility, and the commingling was a bit more important in doing that. So a longer period with that helps us.
I realize how difficult this is, and I by no means trying to minimize that it should be easy just to get this all accomplished. I'm just trying to get some comfort around a specific time frame since this has been going on and on for quite some time. I really don't minimize the difficulty, the job you have in actually trying to accomplish this.
I appreciate it.
Any other comments? Go ahead.
Yeah, I just want to add, Stan. 2 things. I think what you said in terms of all of the success we had, we ought to make note of that. But I think we also have to have room for conversation. One doesn't negate the other. The conversation about pushing and ending punitive seg shouldn't negate all of the good things that we did, right? And we got to be able to have both those conversations. That's number one. Number 2 is part of the struggle with this whole notion about ending punitive seg. Let me just say it as clearly as I can. Secure was supposed to be for the very inmates we're talking about. Secure was supposed to be that option. And what I find hard is that what it was created for, we haven't tested yet we're saying we don't want to use it. If we would have put inmates in Secure and we said the people that came out of Secure, it wasn't working, violence was increasing, there's a direct correlation between Secure and that. But we haven't even tried it. And the department is now coming back saying we can't end it because we need to find other options. And that is the hard part for us to sort of understand. We need to get to a place where we have safe jails for everybody, and we need to figure out how to get there. But that is the struggle. And it's not negating all of the stuff the department did to reduce the number of people in punitive seg. It's not to negate all of the work that was done to enhance programs and enhance people's ability to return home safely and to build new lives. That's not the point. The point is that the notion that it was created for these inmates, we now are saying we can't use.
So let me just take a second to respond to this. That, as I've said before, you can go anywhere in the country. If you can find me another correctional administrator who say that they can do this, what we're doing, just say they could do it, or even would entertain a conversation about doing this, I'd love to talk to them. They don't exist. They're not even thinking about it, never mind doing it. Secure was a concept that we built in our heads. We took it from the juvenile system, never been touched in the jail system. So when you say we built the model, we did. We don't have confidence in the model until we see it work. Our staff don't have confidence until they use it. So Secure, True, Second Chance, those aren't housing areas. per se, because it used to be like segregation, the housing area. I can work seg, you put the inmate in, he stays for a while, he goes out. These are actually skills, staff skills, and how they interact with the offender to help that offender, act in a different way. So it's a much different model, but clearly it is an enormous reach. I mean, it is an enormous reach what we said we were going to do. I can't imagine, I've had other correctional administrators talk to me and said, you're just out of your mind. That's never going to happen. Tell me straight up that I think it will, and I believe we are cutting good ground here to say this can happen and it can happen in a safe way. But it's a skill level, and again, it really is for staff who 3 weeks ago, staff were asking me, can we have a little more time? They were nervous, but they did a great job the first couple of days and then the second week. So in time, just like you're saying, then now the more difficult inmate's going to be, I'm fine, I can manage that. It really was prudent to take a little time to let this evolve. As I've said to some of the board members, I think a bad event would have just stalled us flat, where it would have been hard to restart. And we don't have answers to some of the questions. We haven't done it yet. So we're trying to get those answers.
Other comments, questions? Yes, Ron.
I know that we would not be as far along as we are in terms of limiting solitary confinement without the commissioner's leadership, commitment, and your support and the city's support from the beginning. A huge amount has been accomplished. There were over 600 people. There are 150, whatever, today. And I, as a member of this board, am proud to have been part of that. And I give you full credit because we could not have done that. On the other hand, I still do not understand why what seems to me to be a substantial failure of management within GMDC, which was working very well. You allowed there to be too many alarms rather than to be focused alarms, an issue that you're well aware of, and we've discussed at great length the importance of not having facility-wide alarms when a unit alarm would be sufficient. When you allowed, not you, not you, but your staff allowed, the end of, law library, the basic rules of the Board of Correction, the minimum standards, access to law library, access to sick call, access to follow-up for serious medical problems, access to medication. Half of the people in GMDC were not getting their directly observed therapy. The end of programming, essentially, lack of access of mental health services, and failure to provide people with serious emergency problems with access to medical care. That's what allowed, and it's not surprising to me, nor I'm sure is it surprising to you, that a situation that was allowed to develop in GMDC, which did not exist the week before, resulted in increased violence within the facility. And then it is disturbing to me and doesn't make sense really, that because the facility became chaotic, as we both agree, that you're punished, that you're eliminating the plan to close down solitary confinement because of a violent, situation which was substantially created by a management failure within GMDC. Now, you can say that and say we couldn't do it right now, but that's what happened. It's not because all of a sudden there are 80 terribly violent people on Rikers Island because there were 40 before. Genetics just doesn't go that way. Things don't change dramatically on Rikers Island in terms of the number of people who needed to be in a secure unit. What happened, in fact, was that the facility, because we put too many people in, and when you saw you didn't stop soon enough, and that things got out of control. And now, you're expanding this unit, which, as Brandon said, was down to 7 people. It's really a harmful place. We all recognize that, but I must say that increasing recreation from 2 to 3 hours is meaningless, I believe, to the men, the young adults in solitary confinement, because only 6% of people in solitary confinement go to recreation. And when they get to recreation, they're in isolated cages without any equipment, with the sun in this season beating down on them, and to give them an extra hour of being alone without equipment in a cage,
I don't think is something that, that recognizes the danger and the harm caused by solitary confinement. I would just want to say that this is, I believe that, Commissioner, that you want to end solitary confinement, and I really hope that you do it. It doesn't matter that it's hard for me or for other board members to sit up here month after month after month and be told stuff that doesn't make any sense. I mean, I was in the secure unit on Thursday, did not knowing you were going to be canceling the place down. I was in GMDC when it was problematic. As well. But this is a very serious time in our country, and we need to be de-escalating, not escalating, going from 7 in there to 18. I mean, I would like you to be telling us today how many people are going to be insecure tomorrow, and they're not going to be 18. They're going to be, 12 of them are going to be in ESH, and 6 of them are going to be in secure, and only 2 are going to be there. I mean, why are we not moving substantially forward? I have to say that at this particular moment in our country, to not be moving forward on this, and to bring in, and these are separate issues which we're not going to get to at today's meeting, but to be putting shotguns into the facilities, to be putting tasers into the facilities, is not the way that we should be moving forward.
No, I'm quorum, Bobby.
Well, I'm just about finished.
But these are not relevant to the issue.
Well, I think it's relevant to the issue to not move forward on this.
Bobby, please.
Stan, I'm sorry, I didn't interrupt you.
But it's not interrupting, it's turning into a speech. So if you have questions to ask of the commissioner, please ask them.
No,
my comment is... It has nothing to do with the
is
substance of what you're saying. But there is an item before the board, it's been seconded. Let's try and keep the discussion focused on that, okay?
I thought I was doing that. I hope that the number of people who we're talking about in solitary confinement, maybe I'll ask that as a question, Commissioner. How many of the current people who are in solitary confinement, who are under 22 years of age, can be moved into ESH, can be moved and will be moved into ESH, can be moved and will be moved into secure? How many people will be left in this unit without programming, without the 4 hours, because you're not going to have that for a month? How many people right now are going to be subjected to solitary confinement?
Based on your own criteria for who would get in.
So the 12 would remain at the current moment.
12 will be left?
6 would be removed.
So you'd be down to 12?
And that's a consequence of an individual review that took place. Is that right? That is a product of individual review, right?
Well,
Could you describe the process?
At the current moment, we didn't do any individual reviews. We looked at the criteria which we establishing to put people into punitive seg.
Okay, fine.
And so there's 6 individuals that would not meet that criteria.
And each of the 12, though, will be reviewed.
That's correct.
On
Well,
intervals.
if the variance passes by 5 o'clock tomorrow, I have to submit to the board my review.
One last question. Obviously, concerned about is the harm and positive things. You all are concerned about that as well. If you are successful in getting it down to 6 young adults, and if there's a 16-hour period that's essentially a lockout period I know the board standards are 14 hours, but there's actually 16 hours still, right? From 5 in the morning until 9 p.m. at night, we're talking about 16 hours. So if you only have 6 there, why can there not be an opportunity, which is what all the experts say, young people need to now socialize, they need large muscles. Why could not 1 or 2 of them get out for an hour or 2 here and there and rotate them safely through like a limited
So I think we've said that we're not opposed to that. We just need to build the physical space to create separation for those individuals who cannot commingle in a common gay room, right? So, and right now, so it would be 12, it's not going to be 6 individuals, right? As of today, if we move forward with the plan, we would be removing 6, 12 would remain.
Is there a day room in that unit?
Right.
There is a day room in that unit.
There is a day room, and how many can that accommodate?
So the idea was that they can interact with other inmates who may be in cells, all right? They may actually have enemies in that particular unit, there may be a gang affiliation, so it's a separation issue. How do we keep them separated from each other was part of that problem.
But there is a day room in that unit right now.
It's a day room that also has access to the rest of the cell block.
So I think the day room you're talking about, Bobby, is the multi-purpose room in the back?
Well, some of those ex-Maui units had day rooms also.
Correct.
And as well as the treatment unit, where the sun comes in.
Yes.
So is there a day room independent of that in this unit?
No, we would have to construct it.
Any other questions or comments? So with the conditions as they have been read, I'm going to call the question. All those in favor?
Could Martha reread that condition, because it sounds like it's been tweaked.
Okay, that's fine. Please reread that condition.
So the way it reads now is all 19 to 21-year-old prisoners confined in solitary confinement be provided with the option to lock out for at least 4 hours per day in an adequately sized area of the PSU housing block. I just edited that. The next sentence, 4 hours out of cell time begins immediately. Once programming begins, this 4 hours of out of cell time will include the 2.5 hours of programming.
Okay.
Do the board members understand that, and is that reflective of what?
And that's in addition to the 2 hours of recreation.
Right.
But that doesn't have to be.
So, sorry,
Can
Martha?
I call the question now?
Martha?
Yes.
Excuse me, just real quick, I want you to understand. We've said that we cannot comply immediately with the request for the 4 hours.
4 hours.
Okay?
You need 30 days for that.
Yes.
Oh, so this should have 30 days. in it.
Within 30 days.
Thank you.
Okay. With that condition now tweaked, let's call the question. All those in favor of the variance with conditions, please signify by raising your hand. All those opposed? Motion carries. Now, I know that some board members have to leave, but the H&H has some variances, so I'm going to break from the agenda and go to their variances. We will return to the agenda. So anyone with business on the agenda, please remain.
So before I read the agenda variance questions.
Something I said?
Martha, just to make sure I understand, we will not need to seek the young adult commingling variance because the DOC variance was approved. Thank you.
All right, why don't you just start?
Okay, so the first variance request we have, and we'll entertain questions after I present each of these, relates to the 28-day psychotropic medication variance. So this is a variance that's been in existence for some time. It's a variance to BOC Rule 25B2II. This relates to... Sure.
Just one minute. This is it. You have a statement, a historical statement. Okay, please continue.
Okay, this is a long-standing variance that allows us for stable patients to prescribe psychotropic medications on a 28-day medication cycle for psychotropic medications for mental health patients who are stable and in the general population setting. And so for patients that are unstable, they continue on a 14-day cycle of medications, patients in mental observation settings also. But for patients who leave a mental observation setting, who have been already seen, so this would not bear on anybody who hasn't been seen by a psychiatrist who's missed appointments. We have an existing variance we seek renewal for a 28-day cycle for medication for those stable patients.
So could we put this in the form of a motion and then, by all means. So would someone please move this? And second? Okay, Dr. Cohen?
So in GMDC, half of the people did not get their directly observed therapy during the last week of June. And this motion is essentially about that group of people, right? Because all these drugs are...
No, this is...
But aren't these DOT
No,
medications?
well, so the DOT list is a very small list that is, at GMDC, I would guess 50 or 70 people, but it's a small... 23. So the DOT list is the most important list for us because those are people that are on medications, medical or mental health, for whom we're worried if they don't get a medication, they could die or get sick today. That list is maintained at a very high level every day. We're talking here about patients who are stable, have already been seen by a psychiatrist, are known to be stable, and are taking a psychotropic medication. These are, in the community, this would be a 90-day cycle. For us, we keep it at a 28-day cycle, but the DOT list is different from this.
Yes, please.
A question. We keep dealing with this as a limited variance.
Yeah.
Should we engage in rulemaking around this? This
Absolutely,
sounds like...
yes, absolutely. We had actually 2 years ago sat down to do start the CAPA process around all the mental health rules. This would be extremely welcomed by us. And medical, that's right. We have multiple areas where we seek variances where we should.
Right.
Any other? So can I get I think I'm going to call the question on this while we have all those in favor? Any opposed? Carried unanimously.
So the next variance I'll read, I don't know if it's out of order, but it has to do with the interferon gamma release assay. This is basically a blood test that has replaced the PPD skin test, the Mantoux skin test. It's been in effect again very successfully for a number of years. The infection rate is very stable, very low. It allows us not only to do a much more quick and reliable assessment of really latent tuberculosis infection, but it also, importantly, for people who leave jail precipitously, it allows us to have that result on hand so that we can contact them and see them if they come back. And so this is an important variance, again, one that would benefit from a CAPA process.
Second.
Sorry? Yes. Okay. It's been moved and seconded. Any further discussion on this one? Hearing none, let's call the question. All those in favor? Any opposed? And let's move to the third.
Yes, the third has to do with sharing of information, protected health information around injuries. So as everybody here, I believe, knows, it is not allowable for the health service to share protected health information with the Department of Corrections. That's part of the BOC standards. It's also just part of medical ethics, and our mission is protecting and safeguarding the confidentiality of patients' information. However, we have historically sought a variance so that we could share certain diagnoses and certain information with the Department of Correction around injuries so that they can perform investigations of these injuries. It's in the interest of the patients. It certainly is part of our cooperation with the DOC. So this is a variance that we seek renewal for.
Motion, please. Is there a motion? Motion. Second. Any discussion or question? All those in favor? Any opposed? Once again, carries unanimously.
That should be it.
So that should be it, right? And we're going to hold off on the H&H report until the next meeting, as we are with the discussion on the West facility.
Well, I think that actually it's helpful that we table this until next time. We haven't seen that report. I have no idea about the data that's in it. I saw some incorrect like labels, and so I think that we're going to sit down, go through the data together, our two data teams, and we'll be able to come back with a coherent message. But I think broadly, critical health services like specialty care occur for patients who have seen a doctor or a PA and then are referred to see a specialist. And so I think that we need to make sure that those patients get their care. And I don't think it's true that most of the time when that happens, it's because they don't want to go.
Provide some historical data on this as well, going back 6 months or a year as to whether the access to the building has changed.
Excellent. Thank you.
Okay, thank you very much. So, we're going to move to our last item on the agenda, which is the final public comment period. We have a few speakers. Tonya Krupat.
I just want to apologize.
No, there's nothing.
Well, I would like to stay back.
That's why I got you. Sorry.
Hi, my name is Tanya Krupat from the Osborne Center on Justice, Policy and Practice. In the interest of time, I'm going to shorten my remarks, which will be about visiting and the visiting work group, which I'm a part of, and you'll hear from others. So I just wanted to point out on the DOC website, it talks about the importance of visiting, and it says, we recognize how important it is for inmates and their families and friends to maintain contact with one another. We want your visits to be as pleasant as possible, so we are working to speed up the visit process, strengthen security, improve the central control visit building, and provide information to help you plan your visits. I was going to go through a little bit of each of those and say that we're a little disappointed, very disappointed in some areas, that actually a year after a tremendous amount of rulemaking discussion of visiting, it seems like visiting is actually worse than ever at Rikers Island. And I could go into that in a number of ways, but just a few very concrete asks of the board, that there should be immediate signage put up, that after the plexiglass was installed, it's now in 3 of the facilities, there's no way that a visitor would know that a child is allowed to sit on the lap or that the hand holding is allowed to happen throughout the whole visit. And it seems like training of visit captains and those who oversee the visits has not happened around the rules, that they're not aware of that. And so a rule is only as good as its implementation. Similarly, on the website, there could be a what to expect section that would provide transparency and allow visitors to know what to expect. That has not happened. Also, with the new city council, the law that passed that requires DOC to submit visiting data, there are a lot of very subjective and kind of confusing data points. So the only information I could find was for the last quarter, October to December of 2015. And a lot of these, it said almost 14% of the visits that did not happen were due to visitors not obeying the rules and regulations or being disrespectful to staff. So we don't know what that is, and 10% was for unknown and other. This data is very important in order to monitor and improve visits. And finally, very good ideas are generated out of the visiting work group that we are a little frustrated that they're not moving forward. We have asked for specific time frames to move forward. We're very willing to help with this. Just 2 of the ideas that came out were expedited visiting on designated hours for visitors with children, and in the facilities that have the plexiglass, having the end tables being where children sit so they don't have to pass through all the visitors, which they're not likely to do. So we would like you to push DOC and us to show you some concrete improvements by the next meeting. Thank you.
Tanya, can you give us your comments in written form with the details that you left out?
Yeah, thank you.
Good afternoon. My name is Liz Mayers. I don't think this works. Oh, yeah, maybe it does. I'm a member of the Jails Action Coalition and the Visit Committee advocates and executives of the Department of Correction. When we reach out to families at the Q100 bus stop in Queens, we hear over and over how awful making a visit to Rikers is. And that is just from those who have decided to make a visit. It is generally accepted that contact with family and friends improves outcomes for incarcerated people, giving them support while they are incarcerated and paving the way for smoother transition back to the community. Recognizing how important visits are, in June 2015, a visit committee was established with the goal of improving procedures for the roughly 270,000 visitors who visit Rikers jails each year. The Department of Correction, concurring with the need for improvement, agreed to form a committee which would include advocates from the community and executive staff of the department. We have met multiple times over the past year. Now we have reached the one-year anniversary of the Visit Committee launch, and certain positive changes have been made. But at this juncture, we think it is incumbent on us to express our great disappointment that the experience of visiting is in very important ways just as difficult as it was before we began. Unfortunately, new rules and regulations introduced by the Department of Correction have frequently thwarted positive changes. To our surprise, very shortly after the committee began, new rules were put in place reducing physical contact between visitors and incarcerated individuals. The most unfortunate change was accompanied by the placement of long tables with plexiglass dividers that separate visitors from their loved ones, thereby diminishing the feeling of being together formally available through the use of individual family tables. Although negotiations with the Board of Corrections have resulted in some changes to the directives, for example, allowing children to sit on the lap of the incarcerated person, the long and serpentine position is likely to disturb a visit when the child is unwilling to go around the long table. Also disappointing is the fact that instead of fewer searches, there is sometimes the addition of a canine search of everyone as they exit the Q100 bus. Even before getting on the lengthy visit line to enter the central visit house. Regrettably, this added search has not resulted in the reduction of the number of subsequent searches, one of our original and most important goals. Mothers bringing babies and toddlers to Rikers undergo the most challenging experience, although it is likely that having their child visit is especially beneficial for an incarcerated parent. Visitors continue to report impolite and worse treatment by corrections officers, despite the repeated promise of a special training for officers who come in regular contact with visitors. We do understand that making these changes in a large jail complex is likely to be slow to accomplish, but considering that most of those incarcerated Rikers have not been convicted and in many cases are there because they cannot afford to pay bail, it is extremely important to make sure that family life is as undisturbed as possible under the circumstances. Some of the efforts to make visits less awful are certainly helpful, but these are not nearly enough. Our original goals of reducing the time it takes to make a visit and to assure that the process presents fewer obstacles for the visitor have not been fulfilled, and unfortunately, new regulations mean that new problems must be solved. Thank you very much.
This person is from Cova, Irene. Irene's not here. Vivian Velasquez.
Good afternoon. My name is Vivian Velasquez, and I'm going to talk about a personal experience that I went through on Father's Day with my grandson. On Father's Day, when I got off the queue 100 bus. We went through the search with the K-9. Now, from what I experienced before, when the K-9 stops and sits, that's when they notice that you have some contraband on you. Now, in my case, I was with my grandson. That was the first time I brought my grandson up there. I don't let him know that I'm going to a jail. I make it seem as a fun trip. We're going to see, Papa is in a clinic, he's getting better, and so forth and so on. So the K-9 was searching and sniffing my bags. That's all he did. He didn't sit by me, he didn't stop by me, or anything like that. In any event, they still pulled me in and called me out and put me and my grandson in a humiliating position in the bathroom. They strip searched me. They made my grandson turn around as if he was in timeout, which I do not do at home. Okay, I don't consider that as being part of a discipline and reaction for a child. At that time, he was 7. The reason why I brought him with me that day was because, for one, it was Father's Day. For two, this was going to be the first time that his grandfather was going to miss his birthday, because he was going to be turning 8 on the 16th of June. In any event, upon them searching me and searching my grandson, okay, they made my grandson go to the search as well. They made me take off. I had my monthly cycle. They made me take off what I had under my panties, throw it out. I also have medical conditions that I keep a pad in the back because of GI problems, and I threw it out. And again, my grandson was listening to this, and they didn't find anything, nothing at all, but a tweezer. And I told them that they can keep it because it was just $1. But the other thing that they had was a tape that I bought that I used for my shower cap. And that I took because that I kept because that's I paid for, and that I wanted it back. They didn't find any contraband. There was no reason for me to bring contraband to a facility with my grandson. I do understand that they did have some experiences 2 weeks prior of some parents, unfortunately, using their children to bring in contraband in the facility, but I was not one of them, and I don't feel that I should have been subjected to that. That was the first search. After I went through that search, they allowed me on my visit. I was going to go home because I was already humiliated and furious of having to go through that, especially with my grandson, who is now traumatized, and my therapist explained to me that my grandson now has to seek therapy because he's traumatized of that experience. On top of that, they didn't find not one item of contraband, nothing at all, okay? They still send me out. I went on my visit, but they put me in a booth. Now, I suffer several mental health conditions, and one of them is I suffer chronic phobia, claustrophobic. I cannot be in a claustrophobic, in a closed area. I can't be confined. I have medication for that, and they put me in the booth. My grandson didn't understand why he couldn't touch his grandfather. Okay? I didn't understand why I was in the booth because I did not have anything on me. And when my husband went outside to ask one of the correctional facility officers why was I in the booth if they didn't find anything on me, he said because I was around 5 people and one of them had something, so they chose me and my grandson to go through this humiliating experience. After we left the bathroom, we had to get back on the line and put our stuff in a locker. Now, unfortunately, women, some of us have wires under our bras, and the ringer goes off. Because the ringer went off, I had to once again go through another search, and I had to be sent in the booth. I had boots on at that time, and I took down my zippers because I was ready to take off my boots. But when I went to get up, I tripped, and she immediately said that I was high. And I said, first of all, I don't drink, I don't do drugs. I'm on mental health medications, yes I am, and this is what I take. And I brought them in before, and I showed them. And then she says to me, well, do you know you're not supposed to mix Ambien with anything else? And I says, well, when your badge says MD or PhD, you can tell me what I can mix my Ambien with, but you're not my doctor. But you're more than obliged to call my doctor. In any event, she made me walk through a straight line. She literally made me walk through a straight line to see if I was capable of walking a straight line. So I zipped up my boots, and I walked the straight line, and I turned around, and I walked back. And she says, but you did that really, like, cautious. I says, well, I could turn around, and I'll do it again. And she says, no, it's okay. The captain came inside and says, oh, I go through that with her all the time. All the time. I don't come on those visits all the time. This is the first time I ever brought my grandson, number one. And my husband's only been there for a few days. He was only supposed to do 30 days. So, her stating that I was high, and her stating that she's been with me, through this with me, more than one time, was very, 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 very out of line, and, I just wanted to express that, the experience was so humiliating. My grandson experienced trauma behind it, and I am filing a lawsuit, okay, because I do not feel that I should have gone through that. I saved my ticket. I did not turn it in. I turned in my ID because I want to prove that I was in the booth. Now, when I told the correctional officer about my mental health issues, he left the door open and he said I can come in and out whenever I can. So, the bottom line is that between the 5 people, the person that had the contraband went in, and the person that didn't got subjected to be humiliated in the presence of my grandson. You understand? Made him take out his pockets. He had to go through opening up his legs, take off his sandals, lift up his shirt. My grandson is only 7 years old. He should not have gone through that at all. No child should have to go through that at all. And I'm sorry that there are parents that use their children to do those things. I think that's horrible. But I'm not one. And I'm really, 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 really angry. I haven't been back there since. You know, these correctional officers think that they run the place. They can say and do whatever they want, and they get away with it because they all support each other. Okay? One lady in front of me said, oh, if they have more staff in the room, then the line will go a little faster. The correctional officer came outside and said, what did you say? And she repeated it. And she says, you know what? Get out. Just get out. And she suspended her visits for 45 days just because she spoke the First Amendment, speaking her mind. You understand? You know how many times I had to call because they violated my husband's Eighth Amendment, which is his medical treatment? Several times. And if it wasn't because of me being part of JAC and the help of Jennifer Parrish, okay, and the help of Angela Salomer, I keep getting her last name wrong, but I'm going to get it right one day. If it hadn't been for them, my husband would have not been medically treated properly. He suffers congested heart failure. He cannot breathe. He has sleep apnea. He doesn't sleep. He has several other problems. But if it hadn't been for this organization that I'm a part of, and I'm very proud to say that I'm a part of JAC, that my husband would not have been treated for any of his illnesses and any of his conditions at all, you know. And it's so surprising how everybody left the room, you know, like we don't matter. And that's the same thing what happens when we go on a visit. We don't matter. The CEOs run the show. You're here. You don't go there. You don't know what we experience. We experience humiliating, horrendous, horrific, traumatizing nightmares after leaving that place. Okay? So if today, I always say, it can be me today and you tomorrow. You understand? Look at the head of the correctional officer that was supposed to be in charge of all those funds. Where is he now? Out on bail. How many correctional officers been fired from Rikers Island for the stuff that they have done? You know? Things need to change. They need to change. Visitors shouldn't be treated like a criminal. And things really need to change. Thank you.